Good afternoon and welcome to the Appellate Division First Department. I will commence with the call of the calendar. Council, please pay attention for the call of your case. People versus Raymond Acevedo, submitted. Wilson versus City of New York, appellant.
Yes, Susan Polovich-Keaton for the appellant.
Good afternoon. You have 5 and 1. Respondent.
Good afternoon, Alina Drucker for the city.
Good afternoon. You have 5 minutes. Please keep your voice up when we go to argument.
Thank you.
Catherine versus Derrick is submitted. There is no way I'm going to properly pronounce this case, but I'm going to give it a try. Kariba Para Amble versus Polis. Appellant.
Kieran Corcoran for plaintiff appellant. We can just call him Dominic.
Very good. Thank you. 6 and 2. And again, thank you. Counsel for respondent.
Patrick Rideout of Skadden Arps on behalf of respondents.
Good afternoon. You have 6.
Good afternoon, Your Honor.
People versus Amir Andrews is submitted. Corona versus HHSC 13th Street et al. Appellant.
Good afternoon, Beth Garrick for the appellant.
Good afternoon. Respondent for HHSC.
Anthony DiStefano for respondent HHSC. Good afternoon.
Good afternoon. You have 5 minutes. And respondent City of New York.
This is Ellen Ravitch for the City of New York.
Good afternoon. And you have 5 minutes.
Thank you.
People versus Tyasha Clark is submitted. People versus Alejandro Zaragoza is submitted. Alvarez versus XL Specialty. Appellant.
Alexis Rogoski, Skarzinski Merrick for appellant.
Counsel, you've been granted 3 and 1. Respondent.
Good afternoon. Brian Gluckstein, Sullivan and Cromwell on behalf of the respondent.
You've been granted 3. Muser versus Brooke. Appellant.
Yes, Rachel Schulman for the appellant.
Good afternoon. You've been granted 5 and 1. Respondent.
Good afternoon. Carl Huth Reynolds LLP for the respondent.
Good afternoon. You've been granted 5 minutes. Sanchez versus 1 Burgess Road. Appellant.
Adam Greenberg, the law firm of Harrington, Acco, and Monk for appellant.
Good afternoon. 5 and 1. Respondent.
Martin Moskowitz, Corey and Associates on behalf of respondent.
Good afternoon. You've been granted 5 minutes. People versus David McCullum. Appellant.
Good afternoon. Jose Rodriguez Gonzalez on behalf of the appellant.
Good afternoon. You've been granted 3 and 1. Respondent.
Good afternoon. ADA Diana Lewis for the respondent, the Bronx District Attorney's Office.
Good afternoon. You've been granted 3 minutes. People versus Ali Moa Alawi. Appellant.
Good afternoon, Your Honor. Richard Hirschfeld for appellant.
Good afternoon. You've been granted 7 and 2. Respondent.
Good afternoon, Your Honor. Stephen Kress on behalf of the people.
Good afternoon. You've been granted 7 minutes. Strongbow Consulting versus PricewaterhouseCoopers. Appellant.
Douglas Computer, Your Honor. I'm here.
Good afternoon. You've been granted 5 and 1. Respondent.
Good afternoon, Your Honor. Lawrence Cook for respondent, PricewaterhouseCoopers.
Good afternoon, Mr. Cook. You've been granted 5 minutes. Allstate Insurance versus Bizo Inoua is submitted. First case on the calendar is Wilson versus City of New York. Ms. Polovich-Keaton, you are up. 5 minutes.
Thank you, Your Honor. May it please the court, my name is Susan Polovich-Keaton and I represent the appellant. The First Department and the Court of Appeals are clear on the sufficiency of a notice of claim and what's required therein. The notice of claim requires that the claimant basically provides notice to the municipality. We're talking, time, place, date, all the basics, and a sufficient information for the nature of the occurrence to be clear to the municipality. And the purpose of this is, of course, to allow the municipality to, do an investigation of the claim while all the evidence is fresh. Here in this case, it's very clear that the notice of claim has been sufficient. The time, place, date have all been identified, but furthermore, the negligence was grounded, and this is in the notice of claim, in the cleaning and the clearing of the sidewalk and curb area.
Excuse me, this is Justice Schulman.
Yes.
But what we see in opposition to the motion for summary judgment, given the fact that there was a storm in progress, and based on the notice of claim and the transcript, the 58 transcript, Ms. Wilson acknowledged it was snowing and the guy didn't even start the snow blower. Now in opposition, you raise the issue of misdirection. In other words, the sanitation person told Ms. Wilson to go in a certain way, and the misdirection going that way was arguably a factor in causing her fall. To me, doesn't that sound like a new theory of liability?
Well, respectfully, Your Honor, I disagree. If you look back in the record on page 105 and page 106, this is a municipal employee. He was wearing his uniform. He was actually operating the snowblower. He was holding onto it, and it was running at the time. So Ms.
But
Wilson,
he had not begun clearing the snow. Is
he
that
had not,
correct?
no. It was running. The snowblower was running.
My question was, had he begun clearing the snow?
It's unclear whether he had moved it. I know he was beginning. It's unclear whether had he moved it an inch, had he moved it 2 inches, not clear. But
tell me where in the record he moved it at all.
Well, that's what I'm saying, Connor.
According to my reading of the record, and please, if I missed something, highlight it for me so I can go find it. I saw no indication that he had begun the clearing process.
Well, the fact that he brought the snowblower out and he turned it on and he was standing there at the snowblower.
It's the way you do when you turn on a car in the snow time during the winter time. You warm up the engine. He had not started his process of clearing the snow.
Well, and respectfully, Your Honor, I think that would be a question of fact as to,
Well, show me where it's a question of fact. That's what I'm asking you.
Well, I think it depends how you define starting.
Counsel, this is Judge Gonzalez. Let me be more basic. Where do you have any reference to the employee, the city's employee, or the snowblower in the notice of claim, the complaint, or the bill of particulars?
Sure. If we flip over to there for a moment, the notice of claim, which is found on record page 37, we've got the accumulation of snow and ice on the 5th line, and then we've got the ownership, operation, maintenance, supervision, and control.
No, counsel, let's be simple about this.
Sure.
Where does it talk about a snowblower and a city employee in relationship to a snowblower whose use of the snowblower or whose misdirection as to the plaintiff caused her injury?
Right. The snowblower itself is not mentioned in the notice of claim. However, the fact that they were clearing.
How can you say that that you're not precluded from raising this new theory at this late date?
Well, respectfully, it was not a new theory. The use of the word clearing and cleaning the air, the snow, that shows what the municipality was doing at the time, and that was clear in the complaint as well, that they were in the process of cleaning and clearing.
Okay, you'll have a minute on rebuttal.
Okay, thank you.
Ms. Drucker.
Yes, Your Honor. May it please the court, Alina Drucker on behalf of the city. I wanted to clarify two things. First of all, before I say anything, the page 37 of the record, the notice of claim, is clear that there's absolutely no mention of any city employee. There's no mention of any snow blower. And because of all of that, there was no notice to the city to investigate a line of theory that is not about the accumulation of snow on the sidewalk, but about misdirection or negligent traffic management. It's about the condition of the roadway, not about words said. And then I also wanted to clarify, Your Honors asked about, it's on page 107 of the record. She was asked in a deposition, had he turned on the snowblower yet? And the plaintiff responded, he had just turned it on, but it was not blowing snow yet. It was stationary. Had he started to blow the snow or anything else? No. The point was that even in the course of the city's investigation, none of the facts here would have triggered the idea that what the city would have investigated is was the roadway in such a condition, or did the city exacerbate the condition of the snow and accumulation on the snow that might have caused the injury. The plaintiff testified that the two words were said to her. That's what she said in her 50H hearing. He said, step aside. She walked towards him. He was blocking the roadway where she wanted to pass, and he said, step aside. Based on that, the city's investigation naturally would have been in accumulation of the snow, in the meteorological evidence about when the snow started, whether the storm in progress rule applies. None of this is sufficient to put in front of the city in an investigation, nor in the complaint, by the way, anywhere else in this case, up until in opposition to summary judgment, when the evidence showed actually it was still snowing and the snow in progress rule would clearly closed out this case.
Counsel, can I ask you, can you confirm, did you just say that this wasn't even brought up at the 50H or the deposition, but rather for the first time in the affirmation in opposition to the motion? That's correct?
That's when the theory first was made clear to the city, yes. Before that, this case had always been about snow that was accumulated. The plaintiff has testified in her 50H. She testified that he said to step aside. She stepped to the side. Her foot stepped into deep snow. There was deep snow everywhere because it was a level platform. And she slipped, and she thinks that it was on the curb, that it was lower than the sidewalk because she stepped off the sidewalk. She couldn't tell where the sidewalk started or the street started. Nowhere did she, in her complaint, change that theory to say that the direction that she was given was negligent. It was only in response to the discovery, really, that showed that the snowstorm was still ongoing, and so clearly her whole case had been precluded, that she switched to this new theory that the city employee did something wrong by telling her not to walk through the snowblower, but to step aside. And because that wasn't a theory before, that wasn't a subject of exploration for the city in pre-litigation exploration, nor really in the discovery. So it's really a classic case of you can't change your theory on summary judgment to avoid, once you've charted your course and set a strategy to avoid that, to pursue a different theory that for the first time here. That's what the court below found. That's actually not just that. Even putting the notice of claim aside, the complaint doesn't have this theory in it, and you can't change it at this late date and amend the notice of claim or amend the complaint in this process. And so the court, I respectfully submit, correctly dismissed, and this court should affirm, please.
Thank you so much. Counsel, you have a minute on rebuttal.
Sure, I'll go real fast here. One, I wanted to just point out that during both her 50H and her EBT, she testified that it was snowing. There was never a question that there was it was not snowing at the time. That was always the claim. In both times, she testified during her 50H that she was walking and that she had approached the municipal worker, and she identified him in her 50H hearing, that he told her to step aside. This was both cases, both 50H and EBT, and that can be verified. Just to move on quickly, is that the standard set forth by the First Department and the Court of Appeals is both that the theory has to be able to be findable, to be cognizable in order to be sufficient. And here, there is no new legal theory. This has been her testimony. If this was unclear at all, the municipality never moved to reject the notice of claim, never moved to,
The city doesn't have an obligation to do that in order to raise this argument now.
No, they don't, but they don't claim prejudice either, because this has been over and over again. We've talked about snow, we've talked about the snow removal, we've talked about control over the area. And in notice of claim, there is no case law that says that you have to nail down every single specificity in the notice of claim in terms of the instrumentality of
counsel. Once there's verification that there was snow in progress and that the rule applied, didn't the city's the city could easily argue, and it does, that that's the end of its investigation. The accident was at 4 o'clock in the afternoon. The snow began at 9 in the morning. It ended the next day, and the plaintiff herself says that it was snowing heavily. So once you establish snow in progress, there's no need to further investigate. One could argue.
Well, then that would throw out the Yarborough case, because basically, anytime you undertake to perform any kind of snow removal, you have to do it.
Except the problem you have here, counsel, is that your client admitted they had not started. So you would be in a different position if snow had been blowing out of that machine when she came upon it. But she herself says that he had just turned it on and there was no snow blowing. So the accident was not impacted by any act of clearing.
And with all due respect, I believe that that's a question of fact and not a question of law.
What question of fact? Are you negating that what your adversary read from page 107 in the record is incorrect?
No, Your Honor. I'm not.
Well, then it seems to me that's it.
Okay, well, what I'm suggesting is that you're saying
you have to get around the snow in progress doctrine.
Well, when you're trying to define the word begun, had he pulled up and there's a lot of facts that can cater into that, and there's not any case law on there when snow blowing has actually begun. Had he pulled up and
it usually requires snow blowing out of the chute. Anyway, you're out of time. Thank you so much. We have your arguments.
Thank you, Your Honors.
Thank you. Dominic versus Polis. Counsel for Appellant.
Good afternoon. Kieran Corcoran from Stinson LLP for Plaintiff Appellant Dominic, or Dominic K. We call him Dominic Thomas because we're not trying to mispronounce his last name either. With a name like Kieran, I'm all too familiar. So this appeal is about the fact that in New York, there's a social policy that provides for a claim for breach of an informal fiduciary duty. And at the pleading stage, plaintiff appellant here has met all the requirements to state such a claim. Now, in the Supreme Court below, the Honorable Justice dismissed the claim and the complaint on the grounds that plaintiff had not pled an enforceable oral contract. Now, we didn't plead a contract because we didn't believe we had a contract. So the court spent a lot of time talking about how there was indefiniteness to this supposed oral contract that we had not pled. And the fact remains, plaintiff, to state a breach of informal fiduciary duty.
So, counsel, if I may, what exactly was the promise? Because I looked in the record and I didn't see a promise. I saw allegations of bad conduct by a friend, by a person that the plaintiff thought to be a friend. But I didn't see anything as to, for example, the percentage of equity that was promised or any details as to how this special relationship was supposedly formed.
Well, those are two different questions, and Your Honor is correct. And I think it's a misnomer to focus, as the Supreme Court did, on the word promise, because promise is akin to a contractual obligation, and we set forth each other's rights with each other. What this was an entrustment. One of them gave his expertise in global transitioning and offshore litigation coding and relied upon and entrusted his faith and confidence in his friend to handle the financial aspects and how they would monetize their global business.
So let me push the envelope a little bit. Certainly. So you have a service level agreement, and it says specifically that Excellence and XTD India are independent contractors. And the agreement says there's no agency, there's no partnership, there's no joint venture or employment of any sort. So you have all of that in writing, and I'm listening to what you're saying. somebody who went above and beyond the service level agreement, but how does that translate into a fiduciary obligation, fiduciary relationship, a fiduciary duty? I don't know if it's there.
It's not tethered to the contract. That's exactly the point. And our brief is chapter and verse about how the fiduciary duty can and must be independent of a contractual relationship. And that is what we allege in 15 pages in the complaint here about a decades-long relationship, how plaintiff took less through the service level agreement, sacrificed, gave up other endeavors, gave up profits, gave up compensation. He was playing the long game with his partner and friend. I will direct the court to the AHA sales decision from the second department, that's 58 AD 3rd 6, where a salesperson sacrificed and took less over years and years and years to quote, contribute to the venture, contribute to the team, contribute to the long-term plan of their personal relationship, a confidential relationship. And just because they decided to take less, there can be an independent fiduciary relationship. And that's what we allege here. And it's at the pleading stage.
Even if I was going to say, if I were to agree with you that the fiduciary relationship can be independent from any type of contractual relationship, which, as you're saying, they really did not have per se, what elements did you establish in your complaint that shows the existence of a fiduciary relationship? I know you talked about a long-standing friendship, but isn't a fiduciary relationship something more than that?
Well, it can be both. Your Honor is correct. And that's the Apple Music case, which is the famous Beatle case, says it can be based on personal friendships and or prior business dealings. And here we have both. In our complaint, we allege prior business dealings where our client, plaintiff Dominic, had come to the crisis and aid of defendant and helped bail him out of a bad prior business situation. Then they embarked upon this journey together, this venture, and one relied on the other. This is the essence of the fiduciary relationship. One reposes trust and confidence in the other to basically take care of this aspect of the business for me. Manage it without bias and without conflict, and I'll take care of my end, you take care of your end. And the case law is replete that where there's an entrustment, and in this case, defendant Polis was entrusted with the financial aspects, particularly monetizing the securities and the financial interests in the United States that he had the expertise in. And he said, and it's even in our complaint, just bear with me and we'll all sell out in the end, right? I got your back. This is good for the company. There was an interim investment by a Clearview company. And he said, just bear with me, and exhorted him continually. This is going to be fine. We're all going to sell out in the end. I'm going to take care of you, essentially. And in the end, he took it all for himself. So is there an exact percentage my client should have gotten? No, but he did not deserve to be thrown to the wind. And after 10 years of investing his time, his trust, his confidence, he was given a big fat zero. And that's the essence of a breach of a fiduciary relationship, born of trust and confidence, not born of contract, born of personal relationships, born of years of sacrifice for the long game for each other. And we've alleged it, and this is the pleading stage. And the courts are very clear that this is a factual, highly factual inquiry that should not be decided at the motion to dismiss stage. We have 15 pages. This is not a conclusory pleading that says, oh, you owe me this duty, I deserve it.
Thank you. You'll have 2 minutes on rebuttal.
Thank you.
Okay. Mr. Rideout.
May it please the court, Patrick Rideout of Skadden Arps on behalf of respondents. The critical failure here, the crux of Justice Schechter's opinion, is that plaintiff cites no authority for the proposition that even if there were a fiduciary relationship, that Polis had a fiduciary duty to provide an equity grant in excellence in the absence of an agreement to do so, or otherwise to refrain from selling excellence, an entity in which plaintiff admits he had no ownership. the generic case law that's cited by the plaintiff for the duty of loyalty does not create an obligation to share equity interests. And that's why he has alleged that there was this, quote, understanding that Polis would share in the ultimate success of excellence. There's no allegations as to what that even means, that we'll all sell out. That's in paragraph 25. The same. There's no allegation as to how much equity he was entitled to, when.
Well, let me ask you, Excellence owned 51% of what they call DD India, of which the plaintiff owned 49%. Is that right?
That's correct. So, sorry, go ahead, Justice Kaplan.
And isn't there at least an allegation in the complaint, because that's we're only dealing with the complaint, that that plaintiff helped bail the defendant out of a bad situation in India with a company that they were using. And by doing that, they created a business relationship, and he treated, it was important to him. And in the end, he kind of dropped them completely out of the situation. And even though the plaintiff admits, as he must, that there is no contractual agreement as to exactly what plaintiff shouldn't have gotten, isn't there, at least at this stage, some type of of a fiduciary obligation that needs to be explored?
No, Your Honor. The allegations here are that this gentleman is owed $50 million because he didn't receive profits when Excellence was sold. There is nothing in the record, and there's nothing in the case law to suggest that the mere existence of a fiduciary relationship gives rise to a profit-sharing obligation. And that's why Justice Schechter looked to this court's opinion in Benham and in Strait to say such an indefinite promise cannot be enforceable, and then also look to other cases. For example, if the court were to look to the Castellati decision, which this court rendered several years ago, it's very similar. You had a brother and sister who made an oral arrangement to give future equity in a company after the passing of the parent. Later, the mother died and the sister didn't convey the equity. The brother sued to say, we had a deal, and the court not only rejected the contract claim as violative of the statute of frauds, but said this can't be recast as a breach of fiduciary duty because there's no enforceable arrangement by which this equity would be shared. The plaintiff has argued that this ruling practically erases the informal confidential relationship that may exist under New York law. But Justice Schechter acknowledged that they at least assumed that there may be a fiduciary relationship, but grounded her opinion in the fact that such a relationship does not in and of itself give rise to a profit-sharing obligation. And that's why she looked to the allegations in paragraph 16 that they would share in the future success and said that's not enforceable. It's important to note that there aren't allegations here sufficient to create a fiduciary relationship if you credit the factual allegations as opposed to the legal labels and conclusions. As the court has recognized time and time again in the EBC1 case, in the Marmelstein case, fiduciary duties cannot be unilaterally imposed, and you must allege control and dominance. What plaintiff alleges here is that the parent company dominated the subsidiary. As Justice Gonzalez pointed out earlier, they were independent contractors and there were no duties flowing. But putting that to the side, a control relationship between one entity and another is not the same as establishing control and dominance over the individuals pursuant to the fiduciary relationship. And they just haven't alleged any facts to suggest that there is such control or dominance, or that defendant Polis accepted a fiduciary relationship here. And the actual written documents, instead of the manufactured oral promise, show the opposite. It's also important to note that this claim is time barred. This gentleman knew immediately that he wasn't sharing in the profits of this organization and did nothing about it. The only argument in opposition on appeal is the open repudiation doctrine, which does not apply under this court's authority because this isn't an equitable claim. This is a claim for money damages. And as this court has recognized time and time again, you cannot rely on open repudiation where you're seeking money damages. And that was the case in Syracuse case. So it also belies sense to say that the private equity buyers of this business aided and abetted a tort because they paid the actual owner of the business, the nominal owner, to buy the business, and then didn't direct those proceeds to someone who had a supposed decade-old oral arrangement and no formal ownership interest.
Thank you.
Thank you, Your Honor.
Thank you so much. You have 1 minute on 2 minutes on rebuttal. You're on mute.
Thank you. As to the statute of limitations argument, I think there's really nothing there. The complaint clearly alleges that the breaches at issue here, and we control what we allege to be the breaches, occurred beginning in December of 2017 into the spring, at least, of 2018, well within the 3-year statute of limitations. This case was brought in September of 2020. As to the aiding and abetting issue, again, defendants love to tell us what our case is about. We have alleged specific conduct by the JLL funds, including a conspiracy with Mr. Polis to take one share of excellence, transfer it to JLL XDD for the sole purpose, for de minimis value, of ousting our client as a director of the Indian company and completely taking him out of any economic benefit in this venture. Okay, I'd like to just underscore to the court that the court's required to accept the facts of the complaint and give the plaintiff the benefit of every possible favorable inference with regard to their allegations. Again, this is 15 pages of allegations. If the court, and I'm sure the court has already read the complaint, if the court just looks back at the complaint, I think it will be beyond a doubt that we have, at least at the pleading stage, stated a claim for breach of fiduciary duty and then the aiding and abetting for the other defendants. Unless the court has any further questions, I'll rest.
Thank you.
Thank you.
All right, people. No. Corona versus HHSC, 13th Street Development. Ms. Garrick, you have 5 minutes.
I'm sorry?
You have 5 minutes.
Thank you. Good afternoon, Your Honors. May it please the court. Beth Garrick for the plaintiff appellant. Unless the court wants me to discuss other aspects of the appeal, I'd like to concentrate on the 241-6 argument. I think the main reason why we're here today is because the trial court misunderstood the scope of the industrial code section that we were primarily relying upon, which is 23-1.7E2. The trial court seems to have wanted to discuss that narrowly. If we look at page 29 of the record, which is the decision, where they say that because the plaintiff wasn't in a passageway, a stairway, a ramp, so on, it didn't apply. But by its very terms, that section applies to a workspace. And here, the work that was being performed was dismantling a sidewalk bridge, which was outside on the sidewalk. And plaintiff was injured outside on the sidewalk. So
excuse me, this is Justice Schulman, but how does the tree guard, which is the item in issue that was the substantial factor in causing your client's injury, how does the tree guard relate to the work in progress?
It doesn't.
For this rule to be implicated.
Respectfully, Your Honor, it's actually the opposite. As long as the tree guard was not integral to the work, then it is a sharp projection that is.
But the tree well is not part of the pathway, right? It's not part, the tree well was not part of his workspace. It was adjacent to, parallel to, but not part of his workspace. He wasn't supposed to stand in the tree well to work, right?
No, but in this department.
Might I suggest that you concentrate your arguments on section 200, which I think are a little stronger than this one?
I can, but before I go to section 200, Your Honor, could I just point out to 2 cases which I believe are directly on point for working areas?
Okay, it's your time.
Thank you.
You don't want to heed the court's direction? It's your time to waste. Go ahead.
And just under Smith versus McClear, which is 22 AD 3D 369, First Department 2005, and Smith versus Hines, Working areas are also areas where a person is coming to and from, where they have to pick up their supplies, and that's what he was doing at the time. As far as our 200 argument, I believe that it was premature for the court to decide that, because here we have a conflict in the testimony between the parties. We don't know who installed this tree guard. The city says it wasn't us. The city said there's no way that we would have allowed this to be installed. The only witness that testified for help, the defendant, is somebody who didn't work there at the time. He provides an affidavit.
Counsel, I'm confused. Isn't there a letter from defendant's counsel that says that the tree guard was installed by HHSC 13th Street Development Corporation?
He says it may have been, correct. And that's why we feel that this is premature.
Counsel, it says we have received tentative information from our client that it did indeed install the tree guard in question in this case.
Yes, and they're going to say because it said tentative information that it wasn't determinative, but because of that letter, I absolutely agree with you, Your Honor. That's why we need to take their depositions. They moved for summary judgment before we got to delve into this, and this isn't information that plaintiff has. So when we have conflicting testimony, we should have been able to delve into this before summary judgment was granted. But going back to the 241-6, there is ample authority here where he is actually working. They're in the process of dismantling the tree guard. He is less than 2 feet.
He was not dismantling the tree guard.
I apologize. I misspoke, Your Honors. He was dismantling the sidewalk bridge. And because they were dismantling...
At the moment of this accident, he was traversing the side of his truck to put the nails that he had removed from the planks before lunch into the vehicle.
Absolutely.
So he wasn't actually, actively working. Not that in and of itself matters, but
no,
again, all right, you have time on rebuttal. Mr. DeStefano, we'll hear from you now. 5 minutes.
Thank you, Your Honor. And addressing the tree guard and whether or not, for purposes of Labor Law 200, it constituted a dangerous condition, it's significant here that irrespective of whether or not we installed the tree guard, my clients installed the tree guard, the fact is that it existed for 17 years in that spot.
The fact that something exists forever is irrelevant.
Except, okay? Your Honor,
there's always that first accident, and that's this one. So that by itself doesn't win the game.
Except, Your Honor, the city had inspected the sidewalk multiple times over the course of that 17 years, never issued any violations to us. And in fact, the city...
That's irrelevant also.
But the city is not recognizing it as a dangerous condition. Otherwise, it would have been removed. And in fact, the New York City Park Department standards on which the plaintiffs relied specifically said that if the condition of the tree guard was not maintained safely, then it would be removed by City Department of Parks. We have a permit that was issued. The sponsoring agency was the Department of Parks. It was issued in March of 2013 for the tree pit areas on East 13th Street. And the city never removed that tree guard at that time.
So are you saying that in and of itself means that it's not a dangerous condition? Or is it one thing for us to consider in making that determination?
What I'm saying is that there are 2 city bodies that have inspected this area. There's the Parks Department and there's the city DOT, and neither of them consider this to be a dangerous condition. There's never been an incident there that we're even aware of in 22 years, which is to today, but certainly 17 years by the time that this accident happened. No complaints, no violations. 2 city governing bodies have inspected the area and not found anything wrong with it.
I mean, what I'm saying, I understand that, and I think those are certainly things that the court has to take into consideration. But in looking at the pictures with the scaffold in the position that it was and the area that the plaintiff was working at the time to dismantle the scaffold so that there wasn't free flow and the guard right there, I mean, I think those are all things that court can consider. in determining whether or not this was a dangerous condition. I mean, maybe it be open and obvious, but that also doesn't completely take away from the fact that it might still be a dangerous condition.
But then, Your Honor, we look to the means and methods. We look to the Capabianca case out of this court in 2012, where the plaintiff was standing on a pallet to do his work, and the pallet was wet because of a saw that he was using.
Yeah,
and
this isn't, I don't see how really this is means and method. This is like, you know, a premises situation, you know, a defect in the premises. I don't see this having to do with means and methods. He was, as Justice Manzanet pointed out, at the particular time, he wasn't even doing any work. He was just dropping some stuff off in the truck and traversing the area. I don't think it had anything to do with the means and methods.
Respectfully, Your Honor, the situation that you just gave me was all about means and methods. You explained how the sidewalk bridge was erected in the area. You explained how the 2x4s were laid adjacent to the truck. These are all the means and methods. This is precisely the Capabianca case from this court, 9983rd 139, where again, the plaintiff was working in an area directed by his employer under the control of his employer, and the condition that caused his fall was the shifting of the pallet. Here, it's the shifting of the 2x4s on which he had stepped. So all of these lead directly into Capabianca, and in Capabianca, this court dismissed the 200 claim. So for that reason, this is a means and methods case if that's how we're going to look at it. If it's a condition case, I'll also go back to that from the Court of Appeals decision, Vucetovich, that a tree guard and a tree pit area is under the control of the city, not under the control of the building owner. So if we're going to look at this as it is a dangerous condition, then we have no control over that condition based on the Vucetovich decision. And for that reason, the claim should be dismissed if we, again, are going to look at it that way.
Thank you.
Thank you.
Ms. Ravitch, you have 5 minutes.
Good afternoon, Your Honors. I just want to initially say that ironically, I have construction work outside my window, and I hope they'll be quiet, which they're not, for the next 5 minutes. But hopefully you can hear me okay.
So as the world we live in, Miss Ravitch, we know.
It sure is. As an initial point, I just want to say that the city's interest here obviously is only in a third-party action, and therefore we're not going to get involved at all in the labor law claims or the industrial code, or whether the tree guard was a hazard in the context of a workplace. The record reveals that the city really had no involvement in this accident. And the plaintiff agrees, and the Supreme Court properly dismissed the third-party complaint. While the city urges this court to affirm, if it sees fit to restore the negligence claim against the property owner, it should not determine that the city owned or controlled the tree guard. Most notably, the evidence establishes that the city did not install the tree guard. Obviously, the letter that Justice Gonzalez mentioned is in the record, but in addition, the other evidence submitted on the motions was that the city did not install the tree guard. That is from both the city's witness, Arthur Simpson, and also the plaintiff's witness, Richard Robbins, who used to be a Parks Department employee. In addition, the record searches that the Parks Department did don't show otherwise. And the evidence that the property owner relies on in trying to establish that the city controlled or maintained the tree guard does not establish what they seek to establish. In fact, they cite the fact that the city had removed and replaced the tree guard several years later, and they also cite to an affidavit by a later employee of the Parks Department from another case who makes a statement that the city, that the Parks Department maintains tree guards. But if you look at the record, it's clear that they don't. And in fact, the tree planting standards, which are at card 948 of the record, make it clear that a tree guard is not required, and that the permittee, that you need a permit to put in a tree guard, which there wasn't one here, and that that the permittee has the duty to maintain the tree guard. But in any case,
can I assume that if there was no permit to install a tree guard, that then there would have been no inspection of that installation?
I think that is a safe assumption, and certainly there's not anything in the record that the city performed any kind of installation of the tree guard. Oh, I'm so sorry for the noise. Okay. Can you hear me?
We can hear you.
I'm so sorry. Wow. And so, but in any event, the third party plaintiff, the property owner, has not given any basis for holding the city liable. Okay, it's clear that the city did not install the tree guard, and therefore they would have to show that the city had prior written notice and then failed to do something that they should have done. But there's no evidence in the record of prior written notice, and there's certainly no suggestion that this was a special use and therefore an exception to the requirement for prior written notice. So even if this court restores the negligence cause of action against the property owner, we would submit that it would be proper for the court to affirm dismissal of the third party complaint because there's just no basis for liability from the city.
Thank you so much.
Thank you. I'm so sorry.
No problem.
No control over that.
That's right. 2 minutes on rebuttal.
Thank you, Your Honors. I think as we can see from the arguments by the defendant and the third party defendant, there is a question of fact as to, or at least conflicting testimony as to how the tree guard got there. Going back to the issue of the work site, in the Sergio versus Benjolio
case. Ms. Gehrig, I'm sorry to interrupt you, but even if we were to find that there was some issue that might keep in the owner of the property, under what theory does the city stay in?
I don't think they're a direct defendant.
No, they're not. They're a third party defendant.
Yeah, that's between the two. Respectfully, Your Honor, that would be between the two of them. I'm not really.
That's not your thing.
That's not my issue, and I'd love to be able to go back to the work site because I want to convince Justice Manzanet that it really is worthy of consideration. Under the Sergio case from this department, 168 AD 2nd 25, this court said, we have had occasion to observe that responsibility under Labor Law 241-6 extends not only to the point where the work was actually being conducted, but to the entire site in order to ensure the safety of laborers going to and from the points of actual work. Also, the Smith case that I mentioned before, this court held similarly, saying that a physically defined area where tradesmen routinely traverse to access equipment and materials can be an integral part of the work site. As such, where the worker's injury occurs at such location, a question of fact will be present sufficient to defeat a defendant's summary judgment motion on the issue of whether plaintiff's fall occurred in a working area within the meaning of 23(1.7)(e)(2).
I'm struggling with this argument because I'm not sure what the building owner was supposed to do. On a New York City street, was he supposed to get a permit to block off parking spots that were not near a tree well? I mean, what exactly was the work that was involved here? Was the trucks come, they pick up, they dismantle, they load the materials onto the truck and they drive away. That's it. So how does a landlord control a New York City street? How does a landlord control the small area between where you park and the edge of a sidewalk bridge? So I'm just struggling to call that a pathway. Just really stretches the labor law into an area that I'm not sure it was intended to in this factual. Look, I've been on cases where I have been on panels that have held the path between the mud spot over here and the mud spot over there on a construction site is a path. So I understand what you're saying, but the realities of this factual scenario, we're talking about a New York City street, and the job of this plaintiff was to bring the truck to the site with his co-workers and dismantle a sidewalk bridge.
Your Honor, if I may, first, I think it's a question of fact based on this case law. We don't get dismissed straight out based on that. And second, if I could point your attention to the photographs. The photographs show that the actual scaffolding butted up to the sidewalk bridge, to the tree well. Our experts said all they had to do was cover it with plywood, put some sort of protection. They didn't come forward with any expert who said differently. And in fact, in the respondent's brief, they conceded for the purposes of this argument, they're willing to say it could be a working space. So all I'm asking, they said they are willing to consider that it would be. I see you shaking your head. I could point to the page where you say it. It's page 30.
I could tell you what I said.
But
No, we don't have back and forth, counsel. That's inappropriate. So Ms. Garrick, let's wrap it up. You're over your time.
I understand. All I'm asking is to recognize that based on the case law, based on the photographs, based on my expert, all who said that this was a workspace and all they had to do was cover or protect the tree guard, that you find that there was a question of fact. Let the jury decide whether or not this was a workspace under the prevailing case law from this department.
Thank you.
Thank you.
Thank you, Your Honor.
Cesar Alvarez versus XL Specialty Insurance Company. Mr. Rogoski, you have 3 minutes.
Good afternoon, Your Honors. Alexis Rogoski for appellant. The court below erred by focusing on the timing of the transactions challenged in the adversary proceeding.
Before we even get to that, I have to ask you, why are you even here since you are no longer aggrieved?
In our view, we are aggrieved.
The decision against your client was vacated. So it seems to me that this is a frivolous appeal. Why are you here?
The reason we are here, Your Honor, is that in granting summary judgment against QBE, the court below necessarily interpreted the primary policies that were issued by my client, XL.
That's okay, but they didn't. It wasn't determined as against you, and you have no right to assert anything with regard to QBE. Do you? You have standing to assert arguments with regard to findings as to QBE?
We believe we have standing, Your Honor, because the court's ruling necessarily interpreted our policy and will stand in any further proceedings in this case.
But Mr. Rogoski, isn't it true that there is an outstanding motion for summary judgment relating to your client that hasn't even been decided by the judge yet? And so how can we anticipate what she's going to do and decide the appeal before she decides that decision? I mean, I don't know how she's going to decide, and maybe you were very persuasive in your papers, and so she won't necessarily decide it exactly the way she decided the appeal on QBE. I mean, she vacated the determination against your client.
Right, but the court below has already determined that this adversary proceeding can be split into different claims depending upon what transactions were at issue, and that only certain of those claims go back and fall under the earlier 2015-2016 policy. That's a determination that necessarily was made based on the policy wording of the primary policies that were issued by XL. So that determination that a claim is not a single lawsuit aggrieves XL because it was directly contrary to the position that XL took in opposing the plaintiff's motion for summary judgment.
Okay, you'll have 1 minute on rebuttal. Respondent.
Good afternoon, Your Honors. May it please the court, Brian Gluckstein of Sullivan and Cromwell on behalf of the respondents. Happy to address the substance, but to Your Honor's point, certainly there is a motion for summary judgment that is pending. The respondent's position is that the determinations made by the court below will, in terms of how to interpret Excel's policies, will be in fact binding, and we believe Justice Maisley has said as such. But Your Honors are correct that there is a motion pending to have, after the vacated order against Excel order was issued, to have a new order issued to actually enforce judgment against Excel, and that motion does remain pending. But from our point of view, the lower court did get the substantive issues correct in focusing on the fact that this is a 2017 to 2024 policy claim having arisen in 2019, and that the analysis that was conducted in the November 27th, 2020 decision that provides the substantive basis for the decision was thorough and correct. That analysis requires looking at the prior notice exclusion in the 2017 policy and the fact that endorsement 14 made clear that to the extent there was any confusion that was added later, that only a portion of the claim would be excluded from that policy.
But I'm sorry, this is Judge Shulman, Mr. Gluckstein, but you don't disagree that notwithstanding the substantive findings of the November 2020 order, which was entered on December 1, at the end of the day, after granting re-argument and the entry of the December 29, 2020 order, there is no current order that awards the plaintiff summary judgment against XL for them to have coverage under the 2017-2024 policy, correct?
That is correct, Your Honor.
So if there's no order before us, then in a sense, Mr. Rogoski is really asking us for an advisory opinion as to what may ultimately be ruled in the pending motion that has not been decided by Judge Maisley, correct?
In that respect, procedurally, you are correct, Your Honor. We had the respondents have a motion for summary judgment pending that was necessitated by the fact that, notwithstanding Justice Maisley affirming her view that her analysis in the November 27th order was correct, she said procedurally, we had not been able to move against XL because at the time
they hadn't answered.
XL, correct, Justice Kapnick, had not answered. And once they subsequently answered, that joined issue. So as a technical procedural matter, that was why at the end of that order in December, she vacated the judgment that had been entered against XL.
So, I mean, is the whole pending motion an exercise in futility because it's going to come out, like everybody knows how it's going to come out, and it appears, I don't know if this was before or after, but that papers aren't even due until after the summer. So somebody must be trying to expand the record from what it was before. I mean, is there no chance, and everybody's just like spending a lot of time and money writing briefs on a decision that it's already, could be written? It just seems like a confusing procedural morass to be in.
If I can address that quickly, Justice Kapnick, there is no pending schedule with respect to the motion for summary judgment. And Mr. Rogoski will be able to confirm this. After, as a procedural matter, the order was vacated against XL. We did file a motion to have judgment entered against XL, and XL and the respondents jointly corresponded to the court that we all agreed that entry of an order was permissible on the grounds stated in the November 27th order. So we have viewed as the respondents, why I say I do believe this is an exercise in process over substance, that ultimately that order will be based on the November 27th decision. Now, that being said, Justice Maisley, of course, has not entered an order. and she is free to enter whatever order she wants. But I think it was the understanding of the parties, based on comments that she had made at the motion for rehearing, that the judgment would be entered on the same grounds. But that has not, in fact, happened.
Thank you.
Thank you, Your Honors.
Okay, counsel, you have a minute on rebuttal.
Yes, I just wanted to clarify.
You are not arguing that you will not have an opportunity to contest this determination, are you?
No, we are not.
Because my point is, and I agree with everyone on all the comments that have been made. It seems to me like because of the procedural posture we're in, we are forced to go with what we have in front of us, which is no finding as against to your client. So we cannot issue an advisory opinion based on what we think the judge will do. Do we believe that she will likely issue the same decision and not reverse herself? Probably, but until she does so as against your client, and that appeal comes before us, it is not right for us to determine it at this point.
I appreciate your Honor's comments on that point. If I could just clarify one thing briefly for the record. The stipulation we entered with respect to the pending motion by respondents for summary judgment against XL was that she could decide the motion on the existing briefing that had already been submitted. We did not stipulate that it should be decided based on the existing orders. We do not expect her to change her mind again. Your Honor is correct. But I don't believe there is anything further I can say today that will persuade you that that we have standing to appeal the December order that was entered against QBE.
I appreciate that. Thank you.
And let you move on to your other appeals.
Thank you so much. I appreciate that very much.
Thank you, Your Honors.
Thank you, Your Honor.
Howard Muser versus Adam Brook. Ms. Schulman, you have 5 minutes.
Yes, may it please the court. My name is Rachel Schulman. I represent the third party cross petitioner Adam Brook. Here in the midst of a guardianship proceeding for Judith Brook, his mother, she passed away. She had a temporary guardian appointed at the time, Mr. Rutolo.
As you can imagine, we are quite familiar with this case.
Yes. Okay. So yes, it's a subsequent appeal.
Appeals.
So
plural. Yes.
I personally have been involved. The second one I've been involved with, but there are other notices of appeal that have been filed as well. So on this one, the problem had to do with post-mortem fee requests put in by numerous counsel and other court-appointed parties. Under the MHL 8144D3, any dispute as to the size of the property to be retained shall be determined by the surrogate's court. Here, the Supreme Court
it also
issued
says,
an order,
except for property retained to secure any known claim, lien, or administrative costs of the guardianship pursuant to subsection C and E. You left that part out.
Okay, yes, Your Honor. So we believe it was erroneous here for the Supreme Court to issue an order retaining $500,000 it was, when that decision should have been referred to the surrogate's court because there had been an active dispute put forth by my client as to the size.
Because there had been an active dispute, and basically an active dispute about every single matter that was before the court. So let's be clear. The judge who had this case was intimately familiar with all of the parties, all of the additional professionals who were hired on behalf of the IP, etc. So it seems to me, speaking only for myself, that she would be in the best position to determine the appropriateness of fees, etc. So I don't
Yes,
understand in light of the permissibility of this type of reserve for expenses, why there is this argument.
Yes, Your Honor, I agree that the court who had heard all the evidence would be the one to actually issue the awards in light of performance and whether the guardians and the attorneys who were court appointed performed their duties and were entitled to a fee. It's just that the statute says that the amount initially that is the pot of money shall be determined by the surrogate's court, and in the legislative history there.
It doesn't say that.
Counsel,
It does not say that.
You characterize this as post-mortem attorney's fees, right? But the incapacitated person died March 15th, 2020, and the period in question is January through March 2020. So did you misspeak?
Right. The fee requests have a range of the date. Yes, that's accurate. But the statute itself does say that the dispute as to the size of the property goes to the surrogate's court. So if that is ignored here, that can be ignored
You would
in
agree
every
that
matter.
the surrogate's court and the Supreme Court have concurrent jurisdiction here?
Well, under the Constitution, they do. But you have a provision here that's very direct that says this is the procedure.
But you know, that's not real. It is real. We have Supreme Court justices have concurrent jurisdiction.
I'm not going to dispute the concept that concurrent jurisdiction is viable. However, I'm going to maintain that procedurally this was done in the wrong way, and the legislature is very clear that the amount of the money should be determined by the surrogate's court. And if that didn't happen here, I guess that doesn't have to happen anywhere. And that's just not the legislative intent of how this is supposed to work.
Ms. Schulman, this is Justice Schulman. But this doesn't involve, with an H, no CH. Anyway.
Yeah.
This doesn't involve the administration of the IP or the decedent's estate. All these fees, as Justice Gonzalez was pointing out, all involve the guardianship proceeding, which was squarely before Justice O'Neill Levy. The guardianship proceeding, which was a Supreme Court Article 81 proceeding. So if we're dealing, so that's why I'm trying to understand. I know you don't argue concurrent jurisdiction. We get all that. And I understand that certain matters are best left to the surrogate's court, like death compromises, and we can talk about all that stuff. But here, you do not dispute that the various players on behalf of the IP who are seeking the fees, and of which $500,000 was earmarked for them, that they were all involved in work for the guardianship, not the administration of the estate, for your client to get letters and do all this stuff after her passing. Do you agree with that, Ms. Schulman?
Yeah, to my knowledge, these applications regarded the proceedings solely regarding the guardianship. And the Supreme Court went overbroad as well in looking at all the different counsel who could be awarded fees. So yes, Judith Brooke, the AIP who passed away, she had court-appointed counsel, and there were court evaluators, and there was the guardian. So those would be proper administrative fees.
So are you disagreeing that privately retained attorneys can be paid for administrative expenses related to a guardianship?
No, I'm expressing that Howard Muser's counsel, Adam Brooks' counsel, Hazard's counsel are not part of this.
Didn't Mr. Muser's attorneys bring the initial petition for guardianship?
Yes, but that's not court appointed.
So how is that not related to the guardianship?
I'm not saying it's not related. I'm just saying it's not court-appointed counsel. Muser's counsel, Adam Brooks' counsel, and Nicole Hazard.
So you're saying that because there wasn't an initial application to appoint an attorney to represent the incapacitated person before filing a petition for guardianship, the fact that privately retained attorneys filed the guardianship means they don't get paid?
Correct. I'm saying that when she died, that those lawyers who were privately retained are not to be paid from the guardianship funds retained for the payment of attorneys and court-appointed personnel.
All right, you'll have a minute on rebuttal.
Thank you.
You have 5 minutes.
Thank you. May it please the court, Carl Huth for the respondent, Howard Muser.
Sorry for the mispronunciation.
It's all right. It happens a surprising amount with a 4-letter last name. Mental health law 8116F clearly provides that the court may award reasonable compensation for the attorneys for the petitioners. There's no question that is treated as an administrative expense. It relates to the guardianship. The only case that the petitioner has cited that would exclude the petitioner's counsel from an award is the Anna D. Phippots case out of the 2nd Department. The way the law has developed in the 2nd Department, Phippots has been distinguished and limited by the Marion C.W. case because Phippots applied in a case where the AIP died before the petition was granted and before a guardian was appointed. In Marion C.W., as here, the guardian was appointed, the petition was granted, and therefore the 2nd Department itself distinguished its own earlier Phippots case and found that compensation could be awarded to the petitioner. And that is the way courts in the 2nd Department have applied Phippots and Marion C.W. The Parente case cited in our brief is the Nassau County Court applying it in precisely the way that we urge. More importantly, coming back to the constitutional issue, there is no question the Supreme Court has concurrent jurisdiction. The only argument raised by petitioner on the jurisdictional issue, and I want to be clear, they are not arguing, they do not argue anywhere in their papers that this was an improvident exercise of the court's discretion to retain jurisdiction. They argue that the Supreme Court lacked jurisdiction, and that is a frivolous argument. Under Section 12 of Article 6 of the Constitution, the legislature cannot deprive the Supreme Court of its concurrent jurisdiction with respect to the surrogates court. This was well discussed below. It is in the record of appeal at page 155, among others. The point was raised, the petitioner knew it. The petitioner did not address the constitutional issue in its moving brief, and even in its reply brief, after we argue that their appeal was frivolous, they do not mention the constitutional issue or provide any basis for this court to ignore the Constitution of the state of New York. Now, the court, I'm sure the court is familiar, it has found before this very court in the Denison case that's cited in our papers, Justice Manzanet Daniels was on that panel, that concurrent jurisdiction survives even when the surrogates court has its own avenue to jurisdiction under the statute. The Giangualayo case out of the 4th Department is perfectly on point, as here there were 2 parallel proceedings with the intervening death of a party. And because the Supreme Court had the underlying issues that were relevant to its determination, the Supreme Court, not the surrogates court, which is concerned with the trust and the will documents only, but the Supreme Court was the appropriate one to exercise its discretion to retain jurisdiction and make that determination, which included an award of attorney's fees. Very briefly on sanctions, I do not ask for sanctions often, but this is a case that is being litigated to the ends of the earth with frivolous arguments. There are 4 pending appeals. We prevailed in the first appeal, and they immediately filed a petition for re-argument or leave to appeal to the Court of Appeals, which is still pending. The guardianship case has been going on for more than 2 years. It is clear from the record and from the appeals that this is a litigant who will stop at nothing and is not constrained by the law. And it is a litigant who is not going to stop filing frivolous objections and appeals unless the court gives him a reason to do so. Thank you.
Thank you. Counsel, you have 1 minute on rebuttal.
Thank you. Yes, so as the first point, the MHL 81443 puts out a procedure.
Counsel, I'm going to ask you to focus on why your client shouldn't be sanctioned.
Sure, Your Honor. The narrow issue before the court here is whether the arguments have a meritorious basis to go forward, and whether they're non-frivolous. Here, we're citing a statute with a procedural directive that was not followed. The case law on the second point that my adversary is relying on is from the second department. There's the Enadi Fibats case, which went in favor of my client. There's a subsequent case that tried to distinguish, that did distinguish it, where it said,
how about the argument that Supreme Court doesn't have concurrent jurisdiction, which is specifically your adversary's argument?
I'm not going to argue to the panel that concurrent jurisdiction did not exist. However, there's a statute that was not followed, and if it's not followed here, it's never going to be followed. And for me,
but you say that as though the statute and the failure to follow the statute you allude to procedurally somehow, if that's not followed, it waives the jurisdiction of the court. And I don't understand why you keep on connecting those two things. One has absolutely nothing to do with the other. Either Supreme Court has concurrent jurisdiction and you acknowledge that from below, not just now, or you didn't.
I acknowledge the concurrent jurisdiction of the Supreme Court. I, however, urge the court to issue an order staying what is going on below, which is the hearing regarding the fees, such that the $500,000 award is pot, we'll call it, is vacated. The matter is then referred to the surrogate's court to determine.
I'm trying to understand, why should we do that? If the Supreme Court has concurrent jurisdiction and you're basically conceding that, then how, and you're not arguing that Judge O'Neill Levy in any way abused her discretion, then what argument do you possibly have when she's handled this? And we have tons of cases in Supreme Court where there are Article 81 guardianships, the IPs pass away, and the Supreme Court judges finish everything up in Supreme Court. I have hundreds and hundreds of those in Supreme Court. We did never sent those to a surrogate's court. We handled them. We knew about them. It was the fees during the time of the guardianship, which was before Judge O'Neill Levy. Where is the abuse of discretion in not sending that to someone who would have no idea of what had been going on in this case?
Your Honor, my response is that 8144D3 says disputes of this nature shall go to the surrogate court, and that did not happen, and that it's a very simple argument, and that was erroneous.
Thank you.
Thank you.
Thank you so much. We've got the argument. Gregorio Sanchez versus 1 Burgess Road. Mr. Greenberg, you have 5 minutes, sir.
Good afternoon, Your Honors.
Good afternoon.
The reason why we filed this appeal is that we believe that the lower court made an error in its decision by refusing to consider as much as 3 or possibly 4 pieces of evidence in this case that show the accident could not have occurred as the plaintiff alleges. And if an accident could not have occurred.
But aren't all of those items, even if they were to be considered things that are for a jury to decide and not for the court?
Correct.
You have a plaintiff who says he fell from the scaffold, and your client wasn't present.
Correct. The client was not present.
So it sounds to me like there's an issue of fact. All of his speculation about what he thinks is just that.
Well, I agree with Your Honor that there is a question of fact, but the court granted plaintiff's summary judgment under 240, and I agree with Your Honor that there is a question of fact, which is why I appealed from the decision, because I believe there are numerous questions of fact.
No, but you're saying that it should be dismissed.
No, I'm saying that there are questions of fact. I did not cross move, Your Honor. I oppose.
So, Mr. Greenberg, here the court said that no matter how this accident happened, The bottom line is that it was caused because there was an inadequate safety device. So here, there were no harnesses, there were no lanyards, there were no safeguards, there were no railings. How do you get around that?
Well, we get around it very simply because the plaintiff claims that the scaffold broke and collapsed, and he fell through the middle of it. However, the foreman went immediately, he was present at the site. Immediately after the accident, he went to the steps, the same steps where plaintiff admits he was located immediately after he fell, and he saw the scaffold was totally intact.
So let's talk about that for a minute, because I looked at the photographs and there's a big difference between the two sets of photographs. The plaintiff's photographs show the entire scaffold, as in all three levels of it, and your pictures only show the underside of the first level of the scaffold. There is no overview picture that shows the whole thing. So we have a problem here. How do you get around that?
Well, I'm glad you asked that question, Honor, because the photographs that were taken by plaintiff, by his admission, were taken 3 days after the accident. These are masons. The bricks.
Stop right there. Stop right there.
Scaffolds are typically not taken down every day and re-erected.
No, that's not what happened.
Precisely, which means whatever scaffold was there 3 days later is the same scaffold that was there on the day of his accident.
No, Your Honor, the situation was that the scaffold, when these are masons, so they build the bricks from the ground up. When they reach a certain level, the level that's shown in the foreman's photos, then they raise the scaffold. So at the time of the accident,
you mean they raised the planks?
High. The scaffold.
You mean they raised the planks, not
Correct.
the scaffold? The scaffold is the metal structure that gets pieced together.
Correct. But in addition, the planks have to be raised, and the plaintiff's photographs, when he claims he fell from 20 feet, is disputed because the foreman says this plank.
Let me go back to my question.
6 feet high.
Counsel.
Stop. So let's go back to my original question. Where are the safety devices? The court found there were none. There were none. And you tell me where in the record it says, oh, no, there was a railing. Oh, no, he had a harness. He had this, he had that. Where is that?
A scaffold is a safety device under Labor Law 240, specifically enumerated.
Mr. Greenberg, come on now. You know, we have thousands of cases in this department alone with regard to all of the safety devices that have to be present along with a scaffold, like a harness, like a lanyard, like a railing. Railings are not optional on scaffolds.
Okay, well, Your Honor, the testimony here is that first of all, a scaffold by itself is sufficient, and there's no evidence that you need a harness or anything additional where you have a fully functional scaffold, which is what we have in this case, is a fully functional scaffold.
Hard to argue that when you have a man who falls from it.
Well, Your Honor, we're disputing many things in the case, including that he fell from the scaffold. The fact remains.
Except that you have no witnesses to contradict the plaintiff's statements.
Your Honor, we have a lot of circumstantial evidence.
Including, counsel, the photographs of your photographs of the planks that were under the first level of the scaffold. No,
the planks were, if you look at the scaffold level itself, the planks were fully intact on that level of scaffold.
On the floor, underneath the scaffold, there are two planks that are there. There's no explanation as to how they got there. Ostensibly, they got there because they came off the top of the scaffold when this poor man fell down.
Well, the affidavit.
You will have time on rebuttal. Okay, Mr. Moskowitz, you have 5 minutes.
Yes, may it please the court. Your Honors, you're exactly correct in this case. My client doesn't have to know specifically whether the plank shifted or broke or he went over the side. What he knows is he fell 20 feet from a scaffold that did not provide him the fall protection that he was entitled to. He did not have a harness to hook into. He did not have the railings and proper planking. and he fell. And in the judge's decision, he points out that the Burgess reliance on the ambulance call report is unavailing. There, it says my client fell 20 feet to the ground from a scaffold. And Ms. Suzanne Townsend, who was the paramedic, generated the report and confirmed the narrative contained therein. So the only evidence in this case that's very clear is that my client did not have the safety protection he was supposed to be afforded, and he fell from the scaffold. And whatever debate there might be on whether somebody put planks back in place or whether the planks broke or the planks were not properly butt jointed and fell, that does not have to be proven for us to prevail on this case. All we have to prove—
Mr. Moskowitz, even if in fact he fell 6 feet or 8 feet, that really would not change the result of the result here, would it?
Exactly. It doesn't matter whether his judgment on distance and height is proper, whether he knows the exact cause of why he fell off the scaffold. All he needs to know is he fell off the scaffold and he wasn't provided fall protection. And basically, I have nothing else to add unless the court has questions for me.
Thank you so much. Mr. Greenberg, you have 1 minute on rebuttal.
Yes. First of all, the court said specifically this court has found that post-accident observations by a foreman such as Khan in this case are admissible, and it's circumstantial evidence to prove that the accident could not have occurred.
Observations is one thing, speculations are another.
It's not.
So if I said I saw X, Y, and Z, that's evidence, right?
But he saw the scaffold, he took a photo of the scaffold, and it fails to confirm the plaintiff's claims that the scaffold totally collapsed and he fell through the middle of it. And the most important part of it is that the plaintiff testified that when he fell through the middle of the scaffold, he ended up on the stairs. The stairs were located several feet away from the scaffold. So the fact remains that we have a biomechanical expert who say he could not have fallen through the
Counsel,
scaffold.
that's going to go to damages, isn't it?
No, that goes to liability, because if an accident—
Does it really? Don't unfortunately, don't bodies bounce when they hit? I mean,
No,
come
they
on.
don't bounce to several feet.
Talking, counsel.
There's no evidence.
You know what? Do
Counsel,
not talk
please
over me.
let the judge finish her statement, please.
Really. We have an awful lot of experience with labor law cases, and we have an awful lot of experience with scaffold cases, especially in New York City. I mean, I echo what Judge Manzanet just said. You're asking us to assume evidence that you have not provided in your attempt to defeat a partial summary judgment.
Well, we have provided an affidavit who says that he was located in a position where he could not have fallen through. We have a photo showing the scaffold was intact. We have an affidavit from a biomechanical expert who says the accident could not have happened in the way he says, because he could not have landed where he did. Not only that, but he's claiming that the scaffold plank hit him on the neck and back, and there's no evidence of any injury.
I mean, counsel, look, these are things that I'm sure will be raised at some point during the trial, and our time is up. But we have your arguments, okay?
Thank you very much, Your Honor.
Thank you so much.
Okay, thank you.
People versus David McCullum. Mr. Rodriguez Gonzalez, you have 3 minutes.
May it please the court. Your Honors, my client could not have done more in the 17 years that have passed since his conviction to change his life and turn his life around.
I don't see not an ounce of remorse from your client, not an ounce. He continues to try to give explanations for his behavior, never accepting the absolute emotional carnage he left in his wake.
Your Honor, I will respond that in the record, including the sex offender treatment records, contained the staff evaluator's assessment that he accepts responsibility at the time of his release to parole after 12 years in prison, Your Honor. The clinicians who made the sex offender evaluation concluded that, and I'm going to quote, he takes responsibility for his offense and does not engage in distorted thinking to rationalize or justify his actions. Mr. McCollum in prison not only seriously engaged with treatment, Your Honors, and he was, the evaluators concluded that he internalized the concepts and that he applied it in his life in a consistent and comprehensive way.
So, counsel, just to echo what my colleague just was saying, isn't it correct that in 2015, the defendant interviewed with the New York Center for Neuropsychology and Forensic Behavioral Sciences, and he said we were partying and drinking and sex occurred between men? How does that comport with the horrendous allegations of rape concerning 4 victims? There's nothing that could convince anyone that sex can occur between men with consent when they are underage, drunk soldiers, intoxicated because they were allowed to drink only in the presence of their sergeant. How do you get past that? How do you show that? How do you explain that this defendant has taken responsibility under the circumstances of this statement?
Your Honor, the same report from which Your Honor is reading, at the end, in the conclusion, it unambiguously said that he accepts responsibility and doesn't engage in distorted thinking. In the same report, he is asked what non-consensual, non-consent means, and he responded, sexual activity to which more than to which two persons don't consent to. He talked about the complainants as his victims. He was at the same. There were no allegations of force or violence in the case against him. He was also a young person at the time, and moreover, Your Honor, today
he was their superior, wasn't he? He was a superior officer.
He was a superior to some of the complainants, but Your Honor, there were not any allegations that he used his rank to compel the complainants. That there were no allegations of that.
I don't understand that. If they were allowed to drink, but if they were under the age of legal drinking and they were allowed to drink only in his presence, how do you say that his rank wasn't used in order to groom these persons and eventually rape them?
Your Honor, one of them was under the age of drinking, and they were in Korea, and they were out in bars. There wasn't an allegation that my client provided the drinks. And again, Your Honor, he has faced 12 years in prison. He learned a new trade in prison. He was.
All right, you can tell us about that on rebuttal because we've gone over the time, okay? All right, Ms. Lewis, you have 3 minutes.
Good afternoon. May it please the court, ADA Diana Lewis for the people, for the Bronx District Attorney's Office. I'll be very brief, Your Honors. At the time the appellant committed these sex crimes, he was an E6 staff sergeant in charge of 9 soldiers stationed in Korea. Over the course of approximately 1 year, he anally, manually, orally, sexually assaulted 4 subordinate soldiers, all of whom were too drunk to consent, one of whom was only, as Your Honors know, 19 years old. The fact that the victims were new to the unit added the stress and pressure as they struggled to come to terms with what this squad leader had done to them. One of the victims actually stated that after the appellant sexually assaulted him, that he rolled him over like he was nothing. Unless your honors have any questions, I will just ask that the court affirm the order. Thank you.
Thank you. Mr. Rodriguez Gonzalez, you have 1 more minute.
Your Honors, Mr. McCollum's conduct in prison was described by the correction staff as exceptional and above any standard for inmate conduct. He learned a new trade. After his release in 2015, when he gained his parole, he found a job despite this conviction, found a job and is a constructive member of the community. Today, he has been complying with his parole. This is his only offense. It happened at a time when Mr. McCollum had to hide his sexual identity under the policies that existed at the time in the military.
I really, that argument is so offensive.
Yeah.
It is so offensive to every gay American in this country. The fact that he had to be in the closet under the don't ask, don't tell policy, I regret that he had to endure that. But to claim that as a basis and a reason for his conduct is just reprehensible.
Your Honor, I am mentioning that to compare his current circumstances. He is an openly gay man today. He is in a committed relationship. And he, Your Honor, is at the very minimum for a level 2 classification. He's only 5 points from a level 1. And for the past 17 years, Your Honors, he has redeemed himself. He has served a
How long
sentence.
has he been out?
6 years now. 6 years now.
All right, thank you. We have your arguments.
Thank you.
People versus Ali Moa Alawi. Mr. Hirschfeld, you have 7 minutes.
Thank you. Good afternoon, Your Honors. Richard Hirschfeld for Appellant. The first issue which I would like to address is whether the prosecution met its burden of proof. And under that, the first question is whether for burglary in the second degree, they proved that the premises were in fact a dwelling. Statutory definition under Penal Law 140 sub 3 is a dwelling is usually occupied at night. And as the court undoubtedly knows, Quattlebaum is the seminal decision on what constitutes usual. And in Quattlebaum, the Court of Appeals held that 20 to 30 times a year was not enough for it to be usually occupied at night. Here we have far less than that. It was once in a blue moon when the occupant.
But does that really matter? There's no way that your client would know when the person who resided there was there. So for all intensive purposes, it's a residence.
No, because I don't believe so, Your Honor, because it's an objective test, not a subjective test. You have to enter into a residence, and a residence.
So you're saying if I spend 6 months out of the year in another location, anybody can break into my house while I'm not away because I'm not there, and it's not being used as a residence during those 6 months. Is that your argument?
No, Judge, because the key is usually occupied. And if you
Mr. Hirschfeld, you said that the seminal case is Quattlebaum, and unless I'm mistaken, this quote comes right out of the Quattlebaum case. A dwelling does not lose its character as such merely because its occupant is temporarily absent. So I don't know if that's really a good way of determining it, because that's the case and that's what the Court of Appeals said.
I'd really flip that on its head, Your Honor. He's temporarily there. He's not temporarily absent. He comes in 3 or 4 times a year when he's passing through. And that's, to find that is usually occupied, I think would stretch it beyond any reasonable interpretation of the statute. The second part of the argument, of course, is
you probably turn upside down all the tax laws and all the residency requirements with your argument.
I think it's apples and oranges, Judge, how they consider residence.
touche.
The second part, of course, is whether or not, even if it is a dwelling, that whether or not the people's proof was sufficient to prove that defendant aided and abetted in these particular burglaries, when at best the proof was the only two counts that he was convicted of, they had a photograph of the car in the area. Now perhaps you could argue that there was
They
a
also
facility.
had his statements, right?
They had his statements that, he was given property and he sold the property.
Well, I mean, he said more than that. He acknowledged having an awareness that these items were stolen, right? He clearly left that impression that he assumed some of this stuff was stolen. He said that to the police officers, right?
Yeah. I don't recall that in the statement, but I'll accept that, Your Honor.
Okay, I'll find it for you later. Trust me, it's in there.
But
I'm sorry, it's a page. I'm sorry, page 461, 462 of the records, where Detective Stanley says that your client told him all these items were stolen. That's pretty clear, sir.
That would be pretty clear from the prosecution's point of view. Yes, Your Honor. So then the next question leads to whether or not the statement should have been suppressed, and with that, whether appellant was deprived of effective assistance. Suppression of the statement turned on whether or not there was a warrantless entry into the defendant's home and a warrantless arrest.
Yeah, but wouldn't there be attenuation, even if we assume arguendo that he was unlawfully arrested at the time at his home? By the time he got to the station house, which was 2 hours later, and again, there was interactions with the different officers. It was a different detective that was questioning him, not the ones that were in the car with him. He was offered food and drink. There was attenuation. So any claimed patent violation would have pretty much been rendered moot. I know you don't agree with that, but isn't there a basis for that in the record?
I understand what you're saying, Judge, but from my perspective, is set forth in the brief. When he's pulled out of his home and he's clearly in custody at that point, despite counsel's complete bumbling of the issue, he's brought in handcuffs to this precinct. He's put in the interrogation room. He's handcuffed to a bar, and then finally he's given the Miranda warnings and immediately confesses. I don't think that's attenuation. And if you look at People versus Harris, I believe there was just a 1 hour gap there, and attenuation wasn't found. So I don't think on these facts, with one thing following from the other, where there's illegality from the outset, the point where he's given those rights to potentially cut off that illegality is too soon to the confession to create an argument for attenuation. But in any event, there's also the ineffective assistance issue. He was certainly entitled to an attorney who gave a modicum of preparation and understanding of what the pertinent legal issues were, so that any...
So I'm kind of stuck there, counsel, because here the jury acquitted the defendant of 2 burglaries and deadlocked on 2 other burglaries. So there were 4 counts that ended up being tossed, so to speak. And here he was ultimately convicted of what? A count of burglary in the second, a count of burglary in the third. So you're saying that those four, the 2 acquittals and the 2 deadlocks do not show effective assistance of counsel?
No, Your Honor. What I'm saying is that without that statement, there would have been nothing, no convictions. And counsel's handling of the suppression of that statement was clearly ineffective. He didn't have a clue as to what the pertinent law was. The judge had to tell him, you're a little bit behind on your legal research, because he was arguing one thing in the case, the Seminole case held to the contrary, New York held to the contrary. He was arguing that his primary argument was that the warrant to search, which uncovered nothing, so it was completely irrelevant, should have been voided because there was a fraudulent statement that the defendant was arrested in his home, which would have been one of the critical issues in support of the suppression of the statement, which was the real issue here. He argued, the judge asked him, so I don't understand.
Why don't you give me that on rebuttal? We're past our time, okay?
Thank you. Yes.
All right. Mr. Kress, you have 7 minutes.
Thank you, Your Honor. Good afternoon. And at the outset, I would like to know that, like Ms. Ravitch before me, I too have construction work going on above my apartment. So they've paused for the moment. So I'm going to try to strike while the iron's hot here. So I would like to address the sufficiency argument that my adversary made. He mentioned that the only evidence against the defendant in this case was that, there was a picture of his car in the area with respect to the 2 burglaries of which he was convicted. And there was a lot more evidence than that. With respect to the burglary of the dwelling, Mr. Moore, the co-defendant, can be seen getting out of the defendant's car about a block away from the apartment that was burglarized before the alarm goes off. Then you can see Mr. Moore on video walk into the adjacent building. We know from the police that there was a ladder from that building up to the terrace of the apartment that was burglarized. That happens a few minutes before the alarm goes off. And then you see Mr. Moore leaving that building about 5 or 6 minutes after the alarm goes off, walking down the street and getting back into the defendant's car. I think it's very clear or very reasonable to infer from all of those facts that the defendant was acting as Moore's getaway driver. With respect to the 45th Street burglary, the 3rd-degree burglary count, again, you see a video of someone loading what are stolen items, or what the victim testified to as being stolen items, into a car with Mr. Moore right there. And we also have a video of the defendant's car in that area right around the same time, and tons of phone calls between Moore and the defendant at that time. So again, I think it's reasonable to infer that Mr. Malawi was the person in the video loading those items into the trunk of his car. And I think that also addresses counsel's argument that without the statement, there would be no evidence to convict in this case. I just disagree. No, I know that there were a lot of other points that were raised in counsel's brief and also in the defendant's pro se supplemental brief. I'm happy to address any of those if the court has questions about them. But otherwise, I would ask that the judgment be affirmed.
Thank you. Mr. Hirschfeld, you have 2 more minutes.
Thank you, Your Honor. So once again, just briefly on the ineffective assistance, the court asked to counsel, what his position was, whether defendant was in custody, not in custody. And counsel's answer was, I don't know. It's very confusing. It's all, how do you have an attorney prepare for a hearing, understand what the ultimate goal is, and not take a position on whether the defendant's in custody or not? There's just a complete absence of representation on the suppression issue. Last, I'd like to briefly touch on the Allen charge, in which when the jury was deadlocked, the court came back and said to the jury, look, if you guys don't do it, we'll get another jury in, and if they can do it, there's no reason why you can't do it. And
go ahead, Barbara, Judge Kapnick.
I was just going to say, no, it takes a minute for the mute button to go off. I was just going to say that I did read the judge's Allen charge, and she did say that a little softer than what you just said. But Judge Pickholz is a very experienced trial judge, and she went on to explain it in I thought, a very fair manner. She did say, if you can't do it, no reason if somebody else could do it that you can't. But then she went on. So I really find that it's very difficult. She said a few different times, look, I don't want anybody to do anything that goes against their conscience. And I thought it was balanced. I really did. It's a tough thing that Allen, the Allen charge, you have to give it, but she did really, I thought it was balanced. You kind of forgot the second half of what she said.
I laid it all out in the brief, Your Honor.
Yes, I read it.
She did, give additional instruction, but with that instruction, we submit that the rest, the follow-up really didn't cure that, the harshness of that charge, and the suggestion that, look, we're going to have to do the whole thing over, and somebody else is going to find him guilty or innocent or not guilty. And so you guys can do it just as well. And that's.
And it wasn't like that they came back 5 minutes later. They went home and they spent most of the next day deliberating. They came out with lots of different notes, a lot of different questions. So, you know, hard to say that they didn't seem to be thoughtful about it in order to decide whether they should reach a verdict or not.
I understand. If there are no further questions, we'll rely on our brief. Thank you.
Thank you so much. Sorry, Strongbow Consulting Group LLC versus Price Waterhouse Coopers LLP. Mr. Caputer, you have 5 minutes.
May it please the court, my name is Caputer, I represent Strongbow. The defendant, PwC, drafted the agreements before the court that unmistakably limited the authority of an arbitrator. The defendants have cited no authority for the proposition that even where a valid arbitration agreement exists, if the parties' agreement also limits the scope of the arbitrator's authority, then when a particular claim and issue falls falls outside the scope, within the scope of the limitation, then the remedy is the denial of the motion to compel arbitration. I think the case that was discussed by us in our brief and more abbreviated form by Mr. Cook was the Court of Appeals decision in Boehmer against Boehmer. And I think that was a more difficult case than is presented here, because in Boehmer, there was a broad arbitration agreement, but then there was a specific set of enumerated issues that the parties wanted to put before an arbitrator. So the holding in Boehmer was that when the claimant brought forward a claim that was not enumerated, the fact that there had been enumerated claims didn't revive the general nature of the opening to the arbitration agreement. In this case, we have the exclusive jurisdiction provision of the 2016 non-disclosure agreement, and that NDA couldn't be more clear. It's absolutely the language there. There's no fancy contract construction issues involved. That the exclusive jurisdiction of the courts of New York is what controls confidential information. The 2 years.
Yes, but sir, but we also had the 2018 agreement that you agree and never challenged, which was very broad and very open, and you could recognize that the court can have jurisdiction to address, whether the award was appropriate or not if you were to commence an Article 75. But so that may explain why they want the court in the loop. But you didn't really challenge the 2018 agreement, which supersedes the 2016 agreement.
Well, and which had no forum selection provision.
Respectfully, Your Honor, I think we did challenge that, and we do challenge it in two ways. Even though we first saw that 2018 NDA in reply for the first time, one of the arguments that we have raised is that in order for the 2016 NDA to be superseded, certain criteria have to be met. And those criteria are not met by the 2018 NDA. The 2016 NDA says that it can only be superseded on conditions that there are provisions specific to a particular business objective.
So counsel, I'm going to ask you a real basic kind of question. So why shouldn't an arbitrator decide arbitrability here? Nationwide says that the penetrating analysis of the scope of this type of provision must be left to the arbitrator, right?
It says that, but I believe the facts are distinguishable because in this case, although you have a broad arbitration sentence at one point, you also have a clear limitation on arbitrability. And that clear limitation.
Where is that clear limitation?
That's in the 2016 arbitration agreement, which was, and if I
in the NDA, you mean?
Yes, the NDA. And if I
the 2018 agreement, the agreement, the services agreement comes later, no?
The services agreement came before the 2018 NDA by only 2 days. But at the time the services agreement was signed, it was referring back to the controlling.
Yes, but then you signed the 2018
But then the 2018
NDA, and that one supersedes all other prior agreements between the parties concerning the use, dissemination, and protection of confidential information. So it spoke directly to the 2016 NDA.
I see in the agreement the line that you wrote, but I disagree, that you read rather. I disagree with the interpretation that you're drawing because of what's at the bottom of that same paragraph. And at the bottom of the same paragraph, and this is at page 180 of the record, paragraph 20 of the 2018 NDA, it says this: any confidentiality obligations governing the provision of services by PwC to Strongbow or joint business relationships between PwC and Strongbow shall be governed solely by any agreements related thereto, meaning the service agreement, which agreements shall not be superseded by this agreement. And
all right, you will have a minute on rebuttal and we can discuss that further. Mr. Cook, you have 5 minutes. Unmute your mic, please.
I apologize. After a long day, I'm the first person to make that mistake.
That's okay. It happens to us.
May it please the court. Good afternoon, Your Honors. My name is Lawrence Cook. I represent PricewaterhouseCoopers LLP, the defendant in this lawsuit. I think that there are a number of issues dealing directly with the court's questions of Mr. Caputer that bear considering. The first is the 2016 NDA is not even with the defendant PwC. It is with a different international entity and not the defendant herein. And so there's no question that the 2018 NDA supersedes and governs as between the parties in front of the court and as it relates to the services agreement. I also strongly disagree with Mr. Caputer. I think we have cited legions of cases that stand for the proposition where there is a provision that allows the parties to seek equitable relief in the courts and a provision providing for arbitration. The courts conform those two agreements or those two clauses to allow the parties to seek arbitration and to use the court's equitable jurisdiction in aid of the jurisdiction. Justice Cohen clearly understood that in our nearly hour-long argument on this. I would state instead there is no case cited by Strongbow that goes against this court's repeated, and courts in the Southern District and the Second Circuit's repeated designation that faced with a broad arbitration clause, particularly where the parties incorporate the rules of the arbitral authority, those questions concerning the scope of the claims are issues to be decided by the arbitrator. In other words, arbitrability is decided by the arbitrator. There's no question here that the services agreement contains a broad and mandatory arbitration agreement. There's no question that Nationwide Insurance stands for the proposition that issues of arbitrability are going to be decided by the arbitrator. And I think that based on the Court of Appeals' more recent decision in Garthon, which notably overturned the decision of a panel of this court, although with a dissent by Justice Mazanet, the Court of Appeals in 2 sentences was able to say that where you incorporate the rules, in that case it was the London Arbitral Association, in those circumstances that the issues of arbitrability are to be decided by the arbitrator. All of Mr. Caputer's arguments, to the extent that they have validity, are arguments he can make to the arbitrator, but it is the arbitrator who is charged with deciding whether his claims are or are not covered by the services agreement. I can cite chapter and verse based on this complaint, how all of his complaints facts are rooted in the services agreement. There are 26 references to the services agreement in his complaint. The beginning of the second paragraph of his complaint and the beginning of the third paragraph of his complaint both refer to work that was done under the services agreement. The gravamen of the complaint is the $3.2 million claim that they are making, and that is the amount that they presented as an invoice for work that they did under the statement of work, which was part of the services agreement. If there are any claims that are outside of that, those claims are for the arbitrator to decide, as Justice Cohen clearly enunciated in his relatively short decision following a long oral argument. But there are cases out of the Southern District that Mr. Caputo did not challenge that this case is governed by the FAA because it concerns interstate commerce. And so this court can look to the decisions of the Southern District and the Second Circuit. The policy administration's case, the mobile media case, are all lengthy decisions where judges there considered arguments similar to Strongbow's arguments and ultimately decided that this is all for the arbitrator to decide, not for the courts to decide.
Counsel, can I take a point of preference and just ask you one question? Having spent many, many years in the court system, I once knew someone else with your name, and I was wondering if you had any relationship to that former judge.
Thank you, Your Honor. That's my grandfather, and I was named after him. That's one of the reasons I used the Roman 2 at the end of my name. I was very lucky as a young lawyer. My phone calls were always answered because people would make mistakes.
You were your grandfather? Okay. Well, thank you very much. I couldn't imagine it was not.
Thank you so much.
Thank you, Mr. Caputo, for that moment of just a personal thing. Has nothing to do with
Caputo, you have a minute.
And I missed the lights, Judge. I apologize for my phone going off track. I was tracking my own time.
That's okay.
The defendant argued in its opening brief below that the 2016 NDA incorporates the service agreement. They argued that the 2016 NDA expressly connects the NDA with the service agreement. They agreed that the NDA and the service agreement are necessarily related. So to say that the fact there are different parties ignores the fact that the 2016 NDA applied to any company in the PwC group and also specifically said that any company that received our confidential information would be responsible for its own breaches of the NDA. Our complaint refers to both contracts, but we have to seek damages based on the $3.2 million invoice because there is a limitation of liability that applies to any claims, including our claims for misappropriation of trade secrets and confidential information. As we point out in our briefing, the complaint starts from the very first sentence talking about the injuries that we suffered as a result of the misuse of confidential information. And throughout the complaint, the misuse of confidential information by PwC and the misappropriation of it is a central theme of the pleading. You cannot, as Mr. Cook seeks to do, as PwC argues, ignore the fact that the complaint makes substantial, extensive claims concerning misappropriation of trade secrets that triggers the terms of the NDA, and that is a central focus of our basis for recovery, both in equity and damages.
Thank you so much.
Thank you, Your Honor.
Thank you.
Thank you all for your comment.
And that concludes the session of the Appellate Division First Department. Have a wonderful and glorious afternoon on this wonderful sunny day.
Thank you, Judge. Nobody's doing construction outside my window.